Hello, everyone, and welcome to our webinar on the EU Directive on platform workers. This has been a topic that's been bubbling away in the background over the last couple of years, and I've been very lucky to have Julie on a number of webinars speaking about this, and also on our podcast, the Open Talent Report. So Julie's very kindly given us her time today to talk about it. So thank you very much, Julie. It's really good to see you, and a very warm welcome to our guest as well. So thank you very much, Julie. My name is Conor Heaney. I'm the Managing Director at CXE Global EMEA, where we completely connect talent with opportunity. And as I mentioned, I'm delighted to be joined by Julie van Keekhoven. Julie is an employment lawyer with KPMG Law. Julie, we're just chatting before the show. I think we've known each other coming up to 5 years now, and Julie in her previous company was instrumental in setting up CXC in Belgium, and she's really become a trusted advisor over that last 5 year period. And Julie, I'm going to big you up here, but I think it's fair to say you know a huge amount about Belgian and European employment and labour law, and your trusted counsel. So really great to have you on the show today.
Thank you so much. I'm also very honored to be here and to be speaking about this relevant topic today.
Yeah, it's a really fascinating topic because I think the platform and the gig economy has exploded really since the Great Recession back in the period 2007, 2008, 2010. And I think it's probably fair to say that a lot of the platform operators were taking advantage of inconsistencies at a local and national level in relation to the law. The law simply couldn't catch up with the gig economy, right? So if you're a platform operator, you're probably going to take advantage of that in whatever way you can. And we've seen a huge amount of case law in this area, ranging from the Uber case in the UK to multiple cases, unfortunately, against Deliveroo in Belgium and Netherlands, Glovo in Spain. The list goes on and on and on and on. And I think the object of the EU Directive on platform workers is really to give some legal certainty for gig and platform workers. But I think, as we'll find today, Julie, potentially that comes maybe at the expense of labour market flexibility, just at the time when we need it. Right? We got there's labour shortages pretty much in all major Western markets, right? Most Western labour markets have full employment, or at least close to it. So, the gig and the platform economy could be a bit of a panacea, but let's see how the directive will play out. So just some housekeeping. Thank you, Julie. Just some housekeeping, guys. We're hoping to go for 45 minutes, and we're going to reserve 15 minutes to Q&A at the end. If you have a question, Pete Botto from our marketing team is monitoring the chat. So if it's really burning, please do put it in the chat, and we'll definitely get to it. We're recording the webinar as well, so we'll accept your silence as consent to that. And please take notes as you go along. This is going to be a really great session, so thank you very much. Feel free to add a fun fact into the chat, particularly if we don't know you or you don't know the rest of the group. And with that, we'll get started. So, Julie, the burning question. Well, I suppose, what is the directive, right? What is it first and foremost? When is it intended to come into effect? And what are the timelines associated with it?
Yeah, so the directive has been in the pipeline for 2 years already, and there's still no agreement on the draft text. So safe to say everyone still has time, right? It's European legislation, so it takes time. There are a lot of articles about it. There's a lot of debate about it. What it actually is pending legislative instrument which aims at actually reaching a consensus on the status of platform workers. That's the most important goal. You have said it already, there's a lot of case law, a lot of member states in the European Union have different judgments about what the status of such a platform worker is. Even within the country, there are different rulings about it. So there is a lot of discussion going on. So the directive wants to bring consensus, right? And then the second point of the directive is that it also regulates a little bit the use of algorithms by these platforms, right? Which is also very interesting, I think. And this is an aspect which is not there's not written much about it, but it's very interesting because if the EU directive comes into place, then I think all platforms which fall within the scope of the directive must adapt their way of working.
Yeah. And like Julie, it strikes me, we'll probably go a bit granular if that's okay for our audience, but as I understand it, Julie, there's 5 criteria to really define whether a worker falls within the scope of the proposed platform directive. And I think it's important for our audience to note as well that each European Union state must implement or transpose the directive into their own national law. And although,
Exactly.
yes, go ahead, Julie, sorry.
So indeed, with regard to the time frame, already forgot about that part, but indeed, with regard to the time frame, so there's a draft text made by the European Commission, which now still has to be approved by the Council and the European Parliament. It was not yet approved by the end of this year, but it is expected because Belgium has become president of the council. It is expected that under Belgian presidency, there will be an agreement will be reached between the council and the European Parliament, so that the draft text will be final or will be adopted. And then long story short, member states will have about 2 years to implement or to translate the directive into national legislation. So I would say about, if I may take a guess, I think this will become national legislation by 2027, something
Yes.
like that. That's what I expect. Maybe a little bit sooner, but let's say 2027.
Yeah, it's really interesting, Julie. It's been like a moving feast this date as the EU Commission Council seek to get clarity on the various different drafts of the text and really make sure that some of the definitions around what was a platform worker and isn't a platform
Yes.
worker were refined. But it's interesting that it will still have a different flavor though, Julie, because it still has to be implemented at the actual national EU level. And I had a question, Julie, which is as follows. Are EU member states allowed to opt out of this directive? Or must they implement it?
They must implement it. They must implement it. Of course, the directive always gives some space or room to member states to adopt other or specific rules and legislation, right? So it's a minimum standard, actually, the minimum legislation that comes from within the EU.
It's going to make for an exciting couple of years, Julie, as this is bottomed out. Maybe that's why there's not many organizations actively speaking about it. I know the World Employment Confederation have been particularly vexed on this directive and indeed the topics surrounding it. Julie, it strikes me as interesting in terms of this. The definition seems quite wide, right, in terms of
Yes.
what a platform worker is and whether a platform worker has been matched through an algorithm. And I know we're going to come on to that later, but I think it was forecast by the European Union that by next year there'll be roughly 40 million gig workers that will be in the scope
Yeah.
for this particular legislation or directive. And of course, if it's put out to 2027, then and that sector still grows, so we could be looking at 50, 60 million people. And I think, like we were saying at the outset, the directive is well needed for what could be described as the more vulnerable subset of workers, those operating in the gig economy that almost have to. And what I mean by that, Julie, is that they might have low negotiating power or no negotiating power. They might have zero choice or very limited choice in terms of the jobs they might need to do within the gig economy. And
Yeah.
of course, in my view, and obviously of the EU body, they have very little rights. So, for example, if a gig worker is delivering a pizza, she or he, drops a pizza on their foot and falls over and breaks their leg, they've really no recourse, right, under most national legislators. So, in that context, and for those sort of vulnerable workers, it strikes me as a really good thing, right? Let's protect those that
Yeah,
need
I think
protected.
there's no doubt about it. I think there's
Yes.
no one against that, right?
Yes. Well, I hope not, right? But I think,
Yeah, let's
all
assume.
reasonable, yeah, all reasonable people will, I think, welcome that and welcome those safeguards for those people that are probably most vulnerable in terms of their employment or working practices. But like, if you're a high-end independent contractor or freelancer, right, you're getting your gig or your work through, an Upwork, a freelancer.com, or some of the more bespoke talent marketplaces and platforms out there, you do have high negotiating power because typically she or he will be an IT contractor or a process engineer in a med tech company or a medical device
Yes.
company. They can, within reason, work where they want, name their price. It strikes me, Julie, that they're potentially caught by this directive, and therefore, um, although there's protections for the lower choice, no choice workers, to crudely describe them as that, it almost strangles the higher end of the market. Is that a fair analysis? And what's your view on that?
Yeah, I feel the same way. That they would fall within the scope of the directive as well. It needs to be seen how member states will implement the definition of what a platform is. For instance, here in Belgium, we already have legislation about platform work, which has been in effect as of last year. And the definition is more strict than the definition of the directive. A little bit. It's more nuanced. So that's interesting to see that the definition is the same, but for example, non-profit platforms are excluded by Belgian law, which is not the case by the directive. Also, and the directive excludes activities, small activities, or activities which are, and I'm just looking for the right term, an individual which constitutes not merely minor and purely ancillary, excuse my language, components. So what does do these words mean? How are they to be defined? These are relevant questions, I think. So there is a lot of room for discussion. Then member states still have to implement it, and they may adopt more strict definitions, other definitions, which may apply. So that will be interesting to see, and leave room for even more discussion.
Yeah, I appreciate it. And Julie, just for anyone that is completely unfamiliar with the EU Directive and platform workers, right? They've attended our webinar for the first time. They've seen a bit of our marketing out on LinkedIn. They go, I wonder if we're in the scope for that, which we'll deal with in a few seconds. But Julie, would you mind just defining some of the criteria around what is or isn't a platform worker, and that test, if you like, that the EU Directive has posed in relation to what is a platform worker?
Yeah, I will read it out loud because that's the most
That's good.
easy part, I think. And then
Yes,
if you have
please.
questions, then maybe we can analyze it. So it's defined by Article 2 of the directive, which says that a digital labor platform means any natural or legal person providing a commercial service which meets all of the following requirements. And then there are 3 requirements. 1, it is provided, at least in part, that a distance through electronic means, such as a website or a mobile application. It is provided at the request of a recipient of the service. And 3, it involves, as a necessary and essential component, the organization of work performed by the individuals, irrespective of whether that work is performed online or in a certain location. And then it also defines, and I think that's essential as well, it also defines platform work, which of course is an essential definition. These two go together, I think. So platform work means any work organized through a digital labor platform and performed in the Union the European Union, that is, by an individual on the basis of a contractual relationship between the digital labor platform and the individual, irrespective of whether a contractual relationship exists between the individual and the recipient of the service. That's a lot, right?
Yes.
I don't know if everyone has understood that, but it means it is indeed, as you said, very, very broad. And it means if you have a website where people are actually where recipients of service, so clients actually can offer themselves or say, hi, we need a freelancer, that they fall within the scope of this directive. It is what you said, like matchmakers
Yes.
between freelancers and clients, they would fall within this scope.
Wow. Like, again, just listening to that, Julian, of course, I've read those definitions a number of times, and every time I read those definitions, I'm almost shocked by how broad they are. You
Yeah.
know, the organization of work, right? That's so bloody broad, right? And even if you
Yes.
think about a career site, a large enterprise or medium enterprise career site, right? So, they're advertising freelancer jobs, come and work with big company X or big company Y. We've got a career in freelancing here, right? And there's a matching algorithm to that, right? So they're out there, they're saying, hey, come and work with us.
Yeah.
They submit their CV or their application, whatever way of doing that, that matches with the job, right? They've
Yes.
met two
Exactly.
out of the 5 criteria right out the gate. So what was designed for platforms in that potential scenario or particular scenario, that opens it up to the end user. It's crazy.
Exactly. So it's quite interesting what Belgian law what is added is to say is that that a digital platform is a platform is actually a provider of a paid service, and this is something which is lacking in the directive, right? So it's not a requirement in the directive. So in Belgium, a digital platform is defined as a provider of a paid service who, through an algorithm or any other equivalent methods or technology, is capable of exercising decision-making or control over the manner in which the performances are to be realized. And then it has the same definition. Actually, the following criteria are the same as the directive, but I think it's very interesting that there's an additional element to the definition.
Yeah, I agree. I was just thinking about that example I provided there, Julie. Like if you're an organization and you're direct sourcing or deploying a talent pool technology that's fulfilling that matching capability, and most of them do, or most of them claim to, right? You're organizing the work, there's an algorithm or matching element to it. That's potentially really problematic for those companies and the end user in particular.
Indeed.
Okay, yeah, it's going to be fascinating to see how this particular directive progresses, particularly when it's transposed into international law. The other thing, Julie, I wanted to ask your opinion on, and by the way, I should have put a disclaimer at the start, guys. Although Julie is an eminently qualified employment lawyer, this should not be taken as legal advice. Julie's here on her own time and is just giving an overview of her thoughts on the relevant directive, of course. So please do not take this as legal advice, nor should it be construed as such. But Julie, what is your thoughts? Let's say there's a platform that's headquartered, let's say, for example, in the United States. So it's outside of the European Union net, at least on the face of it, right? But the workers are being engaged in, 5 out of the 27 European Union countries, Belgium, Netherlands, Germany, Ireland, Spain. So
Yeah.
what happens in that scenario, right? Is that platform bound by the responsibilities under the directive?
Well, you will have to see how the member state has implemented this directive. So the member state where the platform worker is working, right? That's the legislation you will have to apply. And then, of course, I assume all member states will say that their legislation applies to everyone performing services within their country. So it doesn't matter where the platform would be located.
Okay.
Otherwise, it would be too easy, you know, to not respect the new legislation. So I assume that will be done by all member states.
Understood. Yeah, I think that makes clear. Otherwise, you might have a flight, if that were the case, to USA or Dubai outside of the
Yes.
EU 27 net, if you like. So, Julie, as most people will appreciate on the webinar today, the freelance platforms or the gig platforms or platforms, their business or commercial model is essentially around finding a freelancer to perform a particular service, right? So whether that's designing a presentation or driving a taxi or their own car or delivering a pizza or a burger or performing a software or coding issue. And that commercial model is typically based on, you know, charging the end client a fee for the service, right? And it's really beneficial to the end user because there's typically no employer's burden, there's no social insurance cost. The worker, she or he bears the responsibility for for the payment of their own taxes because typically there's some form of freelancer or registered independent contractor, right? They've got their own corporate entity, hopefully, or at least their own structure to protect them.
Yes.
But if the directive comes in, and it's coming in, it strikes me that the commercial model of the platforms is going to be completely upended, and the platforms that consider themselves disruptors will essentially be disrupted because they'll have to move from what is a variable cost model, right? Whereby, you know, no fixed costs around the actual cost of engaging or employing someone other than the rate and the fee they put on top, if indeed they charge that to the end client. So like if you're in a platform, if you're a CEO or CFO or COO of a platform at the moment, you're probably thinking, oh my God, our commercial model is about to be upended. Are our
Yes.
clients really going to pay more for the same service because everyone's a bloody employee? There's that presumption of employment. So I suppose my question really is this, Julie, what can platforms start to do now, or at least think about to prepare for this, right? What do they need to be doing in your view,
Yeah.
not your advice, but your
Well,
view?
I think given all the case law that has been there already and within the European Union and the US, you know, and the UK as well. I always forget that you're no longer EU. Sorry. So the UK as well, has been a lot of case law. So I think all CEOs are probably already thinking about, okay, what are we going to do if this keeps on going, and if more and more case law rules in favor of the employees then, or the word platform workers, that is. I call it in favor of, but you know, there's a debate about that as well. I think they are already aware that they need to rethink what they will do with their business model and how they will organize themselves. What this directive adds to that is that you can already organize yourself in a way that's in line with the text of the directive as much as possible. No one expects that the text will change drastically in the following periods. So you can take this text already and organize yourself as much as possible to its wording. But you know, as we discussed already, there's still much room for discussion about the interpretation of this text. So of course you can do it in the most strict way, and then you know it will be fine. But it's difficult, I think, for platforms to do so.
Yeah, I can understand the concern of many platform operators just around their commercial model because it was built on speed, you know, access to talent, cost reduction, you know, no
Yes.
employment taxes. Now essentially that model's being inverted, right? So you can understand the problem there, even if you can get someone employed quickly. But it strikes me, Julie, and this is no CXC plug, but for companies like CXC, there's probably a role to play in almost providing that rebuttal of the presumption of innocence. So almost if you can re-engineer the test, if you like, to show that a worker is truly an independent contractor, and as long as there's an audit and documentary proof there, and there's a way of working. It strikes me that platforms potentially have a defensible position in the event of a claim.
Sure, that's true. That's definitely true. And I think if you can show that this is a topic which you have consciously tackled within your organization, which is that it is something that you are aware of, and that you have an explanation for everything, that you have organized yourself in such a way that you are willing to be compliant, then I think this can be a defense for sure. But you already it's also important that you have a look at what is there already on the national level of the member state in which you are active, because in Belgium, of course, we already have criteria which are more extensive than the ones in the directive. We have 8 criteria, and the directive only has 5. So you have to be aware of the member state that you're working in and that you're providing services in, and then adapt your organization for sure. And if you can do this on paper, and of course in practice as well, but if you have like a policy around it, then that's a big advantage, I think.
Yeah, I agree. I never thought I would feel really sorry for the platform operators, but as you were speaking there, Julie, I was listening, but I was also modeling something in my head, which is as follows. If you accept the premise that the platforms have been built on speed and speed of access to talent across a whole range of geographies, but let's just focus on the European Union for the moment. So, like, if they've got workers in Netherlands, in Germany, in Belgium, in Ireland, in Sweden,
Yes.
in Denmark, like, I'm just sort of totting up the administrative nightmare and the
Yes.
complexity that potentially might arise by failing that presumption by meeting that presumption of employment. It's going to be really difficult for some of the smaller operators, I would imagine.
Difficult, but not impossible.
Okay.
And it will make a strange comparison, but actually big building companies have to do the same already.
Yeah.
They often work with a mixed talent pool of workers and independent workers, you know, depending on the project that needs to be done abroad. And they have to do this already, and the criteria are often more strict than the criteria for platform workers. So it's not there you can see that it is possible, right? How many big building companies are active abroad and in multiple countries. So it's indeed, I think it's key to have very good points of contact in every member state, to have maybe someone like CXC, I can imagine, to guide you through this process in as many countries as possible. And it's rethinking the process of how you operate right now. Yes.
Good. And Julie, we've probably covered elements of this, but really keen to get your thoughts on what are the potential unintended consequences in your view of the draft EU directive?
Yes. I find this to be a difficult question, because it's
All right.
predicting the future a little bit. But I think we covered the most important one already, which is that some platforms which do not focus on these can I call it low-skilled platform workers? I don't mean it disrespectfully in any way, but I think it's the most easy way to describe it, like Uber, Deliveroo, etc. Low income based platforms, that they are of course covered by the directive, but indeed you have many more platforms which truly seek to be a matchmaker between a freelancer, high-skilled freelancer, and a client or company. They will be covered as well. And these people, these freelancers, they do not want to be employees, not in the very least. And the same goes for some Uber platform workers, I can tell. So I think it's the main criticism is that it takes away the free choice of platform workers on one hand, and the free choice of contract parties to choose the kind of relationship that they want. So that's the second thing. Also, I think very interesting in Belgium, there's a lot of discussion right now. We had the most recent case law in which Deliveroo platform workers were considered employees. We have another platform, Takeaway, which does not work with self-employed persons, but with employees. And regarding the applicable joint committees or the applicable sector, they chose like a general sector. They ought this to be applicable, but given the ruling of the new judgment, it's up for discussion that maybe another sector would apply with much better employment conditions. So there's discussion in that way as well, like which sector is then applicable to this platform, which employment conditions apply, etc., etc. So the debate goes on and on.
Yes. It strikes me, Julie, or sorry, I'm wondering more, would the consumer, would she or he be willing to pay more to ensure that workers
Of course,
are
that as
treated
well.
better, right? And also, on the flip side, would the enterprise user or end user be prepared to pay more to ensure that the workers are treated in line with the directive and also that they're compliant? I suppose, most of the enterprises we work with are thinking, well, here's what we want: assurance and reassurance that we're engaging workers compliantly, either directly or indirectly. So I think the cost of compliance, I think most people will eat it, right? They have to.
They will have to, I think, because otherwise there are a lot of things we have to do ourselves again, right? So we actually have to go to the restaurant and eat instead of eating restaurant food at home, maybe.
Yeah.
But indeed, of course, the cost will be a thing as well. Yeah.
Yeah, I
Absolutely.
agree. Julie, the other thing that struck me just in relation to potential unintended consequences, again, because of the wide definitions, right? Those 5 criteria. Like, it strikes me that staffing recruitment companies and the end user could potentially be in the scope of this directive, right? That they could be considered, of course, depending how they're set up, right? They could be considered as a platform. And if you're a contract recruitment company, right, or one handling freelancers, you're probably thinking, oh my God, I never even thought that we'd be touched by that. But because it's so drafted so widely at the EU level, it strikes me that they could actually be in the scope of this.
Yes, they are the matchmakers I was talking about, right?
Yes.
So regardless of for what kind of profile you're providing these services right now, if you're a matchmaker of any sort, then indeed, in a professional context, that is, then of course you can fall within the scope of this directive. I agree with you there, Connor. Yes.
Okay, well that's good. And if there's any staffing leaders on the webinar, it's probably good to sit up and notice that. I'm sure that's piqued your interest for sure. So Julie, I know the directive has to be transposed or translated nationally. But have you any thoughts on the potential risks or fines or sanctions that might be in place at a national level? Have you any indication as to what that might look like?
Yeah, sure. So first of all, there is a sort of protection against dismissal in the directive, included for all platform workers who have who will raise their voice or say something, discuss their status. So that's one thing. With regard to sanctions, I can only speak for here in Belgium, but it's safe to say that if the criteria are met, there will be a legal presumption that the platform worker will be an employee. And then in Belgium, of course, the platform will have to pay social security contributions, not only for the employer, but also for the employee. Arrears in taxes, end of year bonuses, remuneration, holiday pay, etc., etc. The list goes on and on. So there's a lot of, these are only the civil, according civil law sanctions or consequences, that is. There are also criminal sanctions which can be applicable, and these are the highest of the highest level. It's level 4 sanction called here in Belgium, and it goes up to 48,000 euros per employee. So
Jeez.
yeah, it's it's not often that the highest sanction is applied. So, but the bracket is between 4,800 and 48,000 euros per employee. So it's still a lot, even if it's if it's the lowest for 4,800, right?
Gee whiz. That, and you know, that's a huge amount, Julie.
Yes.
And it strikes me that the local enforcement agencies, right, who have responsibility for this, because it's an EU directive, it strikes me, if you look at GDPR, for example, the amount of national cases that the Data Protection Agency in Ireland and Netherlands and Germany have brought against large enterprise is considerable. I think that the potential fines levied at Meta in Ireland alone are just under 1 billion euros, right? So, you know, once the regulators know that they're backed up at the European Union and then they've got the national law locally, it strikes me that they're probably going to go hell for leather on this.
I don't know. So in Belgium, we have this legislation for about a year now,
Yes.
and the main criticism is actually that not much has changed. There is not one single platform who has said, well, now that this legislation is in place, now we all have employees and we have no longer self-employed persons that work for us. So it hasn't changed much. I think it's now mostly considered a guideline for courts. So if there is a case brought before a court, then there is a more clear legislative framework for the judge to apply, with more criteria which are relevant for platform work. So I think this is how it is right now. Of course, we are only 1 year into this new legislation, so we have to see how it goes in the future. I think the same will be for other member states. I'm not quite sure. Maybe you can tell something about how it works in the UK, Connor, but because I think in the UK it's more like a tax thing, right? That is that is enforced via a tax mechanism. Here in Belgium, it's not the case. We have social inspection services, and it's more from the aspect of social security, which is the RVA.
Yes.
Sorry, the RZ, which enforces this kind of legislation and regulation. But so far, there aren't too many cases.
Okay. So it's a case of what's the space? Yeah, Julian, in the UK, they have IR35, which you're quite right,
Yes.
is governed by the UK tax authorities, the HMRC. It was introduced in the private sector a couple of years ago, but they haven't really went after many large private sector employers yet.
Yeah.
They actually focused on the government agencies, and I think there was fines in the aggregate of around 500 million or so UK pounds in the first couple of years. So they really went after it. There's draft legislation pending in Ireland, Julie, on what is a self-employed worker, what is the definition around that, but they haven't been able to get appropriate buy-in at the parliamentary level to get that launched. And the tax authorities have a small team responsible for it called the scope team, but they're badly resourced, right? They're under-resourced, so they haven't really launched any investigations apart from against Ireland's national broadcaster, RTE. They've really hit them over the head, unfortunately for them. But really, I had a question, right? So let's say, for example, EU Directive goes live January 1, 2027. It's transposed into all the different EU states. Will it have a retrospective effect whereby a worker, she or he is engaged in the year previous, they're still engaged by platform Y in 2027 on the same terms and conditions. And that worker brings a case for the previous 2 or 3 years. Will it have retrospective effect in your view?
If the employment relationship is still ongoing, then yes, I believe so, yeah. Because of course, if the employment relationship hasn't changed in 2027, then it will be considered as a whole, and of course, on the date that this claim is brought, then it will be analyzed what the status of the employment relationship is. So yes, but a lot depends also again on national legislation. Even if so in Belgium, should the employment relationship have been terminated, it would be different, of course. In Belgium, that is.
Okay, understood. So, so let's say worker is terminated December 31st, 2026, no longer engaged by platform in 2027. In that scenario, would a worker potentially have retrospective claim?
Normally, no, because of course the platform wasn't bound by any legislation on that date yet. So, in principle, no.
Okay, understood. It would probably be quite punitive if that were to be the case. And
Yes, of course, you can always ask the court to interpret national legislation in accordance with European legislation, and there you have room for discussion. But it's very technical. I will not go into that, but in principle, I would say no.
Okay, understood. Well, Julie, thanks for that. Julie, it looks like we're coming up to 45 minutes to the hour. I seen a question come in from Scott Wilson from Eventi Solutions. Scott, I've just unmuted you and would be keen to hear your question if you're okay to shout.
Sure. Yeah, sure. Sorry, Connor, I wasn't ready for you to just transfer to me.
Oh, sorry, mate. Lovely to
No,
hear
no,
you.
no, 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 you're good. What happens if you're a platform worker and you're working in Europe, but the organization's platform isn't sitting in Europe?
Great question. Julie, I'm going to defer to you in this one, but I think I've got my own answer, but I'd rather we go with the proper lawyer. Julie?
Yeah. So the platform work is performed within the European Union, right?
Yes.
Yeah. Okay. So as I said already, I think you have to look at the national legislation of the country where the platform work is performed. It will probably state that this legislation applies to the platform worker who performs work within this country, and then the platform has to oblige by these rules, even regardless of where the platform is located.
Yeah, and I think
That
in that circumstance, Julie, you would go to the national body that regulates employment, or like an unfair dismissals or employment tribunal. Is that correct?
should you want to challenge the status?
Yes. Yes.
Yes, indeed. Yeah.
Good. Good stuff. Thanks, Julie. Scott, any follow-up on that, or does that answer your question fully?
No follow-up. Does it answer the question? We'll have to wait and see.
It's a complicated answer, right? In the sense that it will be a lot of work for platforms indeed to comply with all of it. Yeah.
Great. Thanks, Julie. Thanks, Connor.
Thanks, Scott. Thanks, Julie. Folks, do we have any further questions? Okay, no further questions. So, Julie, I think you've did an excellent job of describing the EU Directive and the challenges for platforms, potential end users, and of course, staffing companies as well, because it's so broadly drafted in the current form. So guys, thanks very much for attending today's webinar. I really hope you found it thought-provoking, but of course, interesting and indeed informative. If you need to find out more information on the EU Directive, please do scan the QR code here, and we've produced a really nice booklet on it that's very informative. Should you wish to connect with either Julie or myself, or indeed both of us, Again, there's a QR code available here. But guys, thanks very much for all of our audience today. Julie, thank you very much indeed for
Thank you.
joining us as a panelist today. It was really informative and really brilliant. And thanks to Pete Botto and our marketing team for organizing everyone and keeping us on track. So thank you very much, everyone. Have a great evening ahead or great day.
Thank you. Have a nice evening.
Thank you. You too, Julie. Thanks again.
Thank you, Graham. Take care, everyone.
Take care. Thanks.